I'm Dr. Mike Gordon from the University of Liverpool, and this video is about the European Union Withdrawal Bill. What we're going to look at in this video is what the bill is and what it does, what the constitutional issues it raises are, and what happens next as the bill progresses through Parliament. So first of all, what is the bill? Well, this bill is the key piece of legislation that is part of our domestic preparations for Brexit, for leaving the European Union. So the job of the legislation is to provide, as the government says, continuity and certainty in our legal system as we leave the EU and EU law stops having legal force, direct legal force in the UK. So the bill's got to do a couple of things. It's got to create new legal architecture and arrangements to account for all those rules that have previously derived from EU law by virtue of our membership and have legal force in the UK for that reason. It's got to create a new legal system, effectively, establishing the status of those rules and the content of them as well. And it's also got to, secondly, give powers largely to the government to modify legal rules which are influenced by or derived from EU law, to get rid of any deficiencies or issues that might be created from the fact of our exiting the EU. So the old EU rules may no longer work exactly correctly in the UK because the UK is no longer going to be a member state of the EU. So this bill is about creating new legal systems and also giving powers to change our domestic legal system, which has been so heavily influenced by EU law during our 40+ years of membership. So that's the sort of the idea or the purpose behind the EU Withdrawal Bill. What constitutional issues then does it raise? Well, there's quite a few, but I'm just going to sort of pick out three. First of all, there are issues constitutionally related to the status and definition of what the bill calls retained EU law. Retained EU law is effectively a new category of legal rules that the bill will create, in effect replacing EU law as it used to operate in the UK, and it will take those rules and make them domestic law. Even though it's called retained EU law, it will make them domestic law and operable in the UK. And there are constitutional issues about how exactly that body of rules, retained EU law, is defined, how long it will last, and also how it relates to other legal rules in our domestic system. So the government's plan, for example, to preserve continuity, is that retained EU law will have precedence over domestic law that currently exists on the books. And how long that relationship between those rules lasts is going to be an important constitutional issue to be determined. A second constitutional issue then raised by the bill is in relation to the powers that it gives the government to modify domestic rules or retained EU law, this body of rules that we're bringing into the UK's legal system, the powers that are given to the government in terms of the scale of the change that might be necessary. Because leaving the EU is going to be a major task. Many changes to our legal system will be required. Some of them will be technical in nature, removing references to EU law or EU institutions or other member states, for example, from rules within the UK's legal system. But other changes might actually have quite significant policy implications. So, for example, where a European institution exercises some kind of administrative function, well, we need to decide what we're going to replace that with. Are we going to create a new public authority in the UK? And the bill gives very significant powers to the government to make a lot of decisions. The estimates about how much lawmaking is going to be required are very imprecise, but at least 800 to 1,000 pieces of legislative change might be required under this bill, which is a huge amount of lawmaking in a short period of time as we aim to exit the EU by the end of March 2019. So exactly how far the government is scrutinised in exercising these very wide-ranging powers is an important and difficult question that the bill has to balance, and it's been much criticised for the balance that it strikes, that Parliament maybe doesn't have enough of a role in affirming the legislation that the government will create under this bill, under the powers, the delegated legislative powers given in this bill. So the third issue then is about devolution, and it's about the powers of the Scottish government and the Welsh government, for example, to change their own legal rules where power has been devolved from the UK level to Scotland, Wales and Northern Ireland, It's about the issue in relation to devolution is how far the bill will make changes in those areas, in those countries of the UK, with their consent or without their consent, and also how far the bill will limit, say, the Scottish Parliament or the Welsh Assembly from making legislative changes that would interfere with the changes to retained EU law that the UK government wants to make for the UK as a whole. So there's very sensitive issues about the idea that this bill will impose a limit on the devolved governments to prevent them from legislating in their own areas in a way which is incompatible with the UK government's definition of retained EU law. So there's all sorts of difficult constitutional sensitivities around that as well. And those are just 3 examples of the constitutional issues posed by this bill. What happens next then? Well, first of all, we're going to see the bill continue to be debated and amended as it goes through Parliament. First through the House of Commons, through the committee stage, and then on into the House of Lords as well. So there could be quite a lot of back and forth as this bill is amended. Maybe the government powers are cut down, maybe some imprecisions about the definition of retained EU law are tightened up and clarified. So the bill will still work its way through Parliament. But in relation to the issues with devolution, a real constitutional flashpoint potentially will be whether the Scottish Parliament and the Welsh Assembly in particular, because the Northern Ireland Assembly is currently without an executive, but there'll be real issues about whether those devolved institutions give their consent to this bill passing. Now that consent isn't legally required. The Supreme Court clarified that in the Miller case earlier on in 2017. But as a matter of convention, constitutional convention, something which is seen as obligatory but not legally binding, we would usually expect a bill of this kind which changes the competence of the legislative powers in Scotland and Wales to be subject to their approval. And at the moment, the Scottish Government and Welsh Government are saying they won't consent to this bill. So as it's amended and works through the UK Parliament, the question will be, can it be amended to such an extent that it will gain the consent of the devolved institutions, or will they refuse to give consent? And if so, what happens then? It would be a real constitutional crisis potentially with that level of disagreement about a bill of this magnitude. The final thing I suppose we need to think about in terms of what happens next is, once the bill is enacted and the law becomes legislation, how those vast powers that are potentially going to be given to the government are used. And there'll be a real job for Parliament in scrutinising the use of the delegated powers contained in this bill as the government goes through that act of making some quite technical changes, but some quite big policy changes to the UK's domestic legal system as I say, in a very short space of time. How well that process of using the powers that this bill is likely to establish can be scrutinised is going to be another crucial constitutional issue to consider for the future. So that's just an overview really of what is a very complex piece of legislation, and it's going to be a bill of major constitutional significance in Brexit as we take that process forward, but also in general it's going to have really important implications for some important constitutional values in the UK. Certainly ideas of democratic scrutiny of the government's activity are going to be important. The relationship between the UK Parliament and government is going to be tested by this process, and also the relationships between the devolved institutions in Scotland, Wales and Northern Ireland and the UK as well. So there are huge constitutional implications related to Brexit, but also just related to the functioning of the UK's constitution as well, raised by this bill. And that, as a final point, is just one part of the picture as well, because the Brexit bill, as it's being called, the Withdrawal Bill, is the main piece of legislation preparing the UK's legal system for exit from the EU, but it's not the only one. At the same time, we're going to have substantive new pieces of law in areas like immigration and trade and agriculture, where EU rules have been so pervasive in the past that we need entirely new legislation, and that'll have to be put in place at the same time as this bill is being discussed, and then the powers under it are being exercised. And also, at the same time, the government is continuing the negotiations at the European level about what our exit deal will look like, if there is an exit deal, and what our future relationship might look like if we ever get on to discussing that as well. So there's a huge amount of activity at the moment associated with Brexit, and a very short amount of time to do it. This bill is a crucial part of the picture, and it raises some difficult issues, but it's still just one challenge of many as the UK exits the European Union.